What is today's date? 1/11/22. Charday, we're good? All right. So welcome everyone. Thanks for being here at this what we have deemed, as we've done in the past, an emergency beer board meeting. To legal counsel, we have 1, 2, 3, 4, 5 board members, including myself. Do I need to list those for the record? Or just, if my preference would be just so we have it on the record for those, because we have a number of call-in users, if each beer board member could just real quick speak their name to those that are here into the microphone for the record.
Kia Garman.
Joe Perlin.
Will Conway.
Bailey Spalding.
Thank you, guys. That's a little bit out of the norm, but we haven't been in this room in a long, long time. So, including myself, we do have a quorum today. Again, thanks for being here. The meeting has been called to effectively install new rules regarding mobile beer permits in Davidson County. As most that are here in the audience today and on the call, legislation a few months ago removed that ability. Most recently, legislation was just passed at council. Most recently, legislation was just passed at council that would allow it, so long as the governing authority, in this case the Metro Beer Board, created rules and regulations to do just that, to regulate the industry. So we are here today in advance of today's meeting. A copy of the proposed rules and regulations were a part of the public notice. We will have a period at the end for Q&A, or I'll say questions, and that we hope to be able to answer, with the understanding that this is very new to our process here in Davidson County. So we may not have all of the finite answers, and understand that it's not like we're putting toothpaste back in the tube. It's like we're putting toothpaste in the tube to begin with. So, so bear with us. On that note, to legal counsel, we have been given a copy and reviewed the copy. I'm going to trust the board has fully reviewed the proposed rules and regs prior to now. Typically, when we're doing something like this, if it's on as an agenda, not just a special meeting for this purpose, we'd ask for a motion, a second, and then discuss. Is that, in your opinion, is that the best way to proceed in today's matter?
Yes, in order to procedurally,
right.
The board's going to take any action or deliberate towards any decision. At least a motion on the first.
Got it. Okay, very well. So, any comments before I ask for a motion, or any comments that any of the board members want to make in advance of me asking for a motion, so that we can discuss any questions, any issues with the proposed regs? Seeing and hearing none, I would ask for a motion to accept the mobile beer permit, the new mobile beer permit rules and regulations as drafted.
So moved.
I have a motion by Mr. Perlin.
Second.
I have a second by Mr. Conway. Gentlemen, thank you. Now, discussion. I'll start it off and say that myself and the director, along with staff and legal counsel, we've spent a good bit of time working on these. And as I said earlier, all the answers are probably not here today, because the industry and the hospitality industry as a whole, they do a fantastic job of finding openings to do things that we haven't addressed And we don't look at that as a bad thing. We look at that as them just taking advantage of of what's on the books and doing what they are legally or regulatory wise allowed. And we certainly appreciate that. But it's not, all the answers may not be today. And I do want to thank the director and staff for all the time and effort that's been put in, and to the board for working through this process, and providing commentary for us all to get here. So to that point, we do have a motion on the table. We have a second, and at this point, I would open it up to comments or questions from the board.
I have a quick question.
Yes, ma'am.
In the suggested changes page here, it talks about disorderly, shall not operate a disorderly mobile establishment nor permit disorderly or unlawful conduct by patrons. I guess what would be the ramifications? Would it be loss of permit, or a fine if you had, bad behavior or disorderly or unlawful conduct by the patrons? Or I guess what would be the potential ramifications for something like that?
Sure. So I'll answer the question, and I'll let the director have his say as well. The idea with this permit is it's not unlike any other permit. As a matter of fact, and there's a part of this rule that says if you have a beer permit, you have to abide by any and all other metro regulations, state law, federal laws, whatever is on the books. We have authority so long as you have a beer permit. So the disorderly conduct or unlawful conduct, this is an opinion statement, so don't hold me to the legal binding of this. If it's unlawful or disorderly, those by definition are created somewhere. So it's unlawful, it's against some law. If it's disorderly, you're out of order. A lot of the things that we do and the way we adjudicate is a preponderance of the evidence. So it's a matter of one side making an accusation, a lot of times being a beer board inspector or Metro Police, or in this case, the Metro Transportation Licensing Commission. At the end of the day, they still have to operate in a lawful and orderly fashion. And then if they're brought in front of this board, just like if they had an on-premise brick and mortar location and there was a fight broke out or someone got shot or something happened that was reported that the owners or the operators of the establishment were perceived as allowing it to happen. And they would come in front of us and we would see that in the same light. Because they have a beer permit, we have that authority. Director, do you want to add any comment to that?
Thank you, Mr. Chair. I would just echo what the chairman said, that basically if they're found to be in violation or cited by another governing authority, in this case, then they would come before the board, and then the board would make a determination about whether or not they should take action against their beer permit at that time. So there's nothing out of the ordinary about the language in there, and we have it in other sections, I believe, of our rules as well. And so I think it would just be like any other complaint that came before the board, and you guys would make that determination and go from there.
Any other questions?
I have a couple of comments. Under G, I'd like for us to just spell out all of those acronyms so that it's very clear for everyone. And then my only other question was about inspection. So this is really a question for our inspectors and our staff. How will we inspect these? So, you know, brick and mortar, they're there. We walk in, they're there. How will we inspect these? Are we stopping them randomly when we see them? Like, what is the protocol there?
I think first there will be an initial inspection where we'll meet with the business owner and discuss the requirements and what we look for when the inspectors come out to conduct the inspection. Then from that point, of course, we may get complaints and we'll have to conduct complaint inspections. But as far as a regulatory inspection, I believe it would be best practice to conduct that inspection at a point when they are stopped at a location. When they are stopped at a location, as not to interfere with their business moving forward.
Yeah.
Only other question I think I had was the police department sent over suggested changes, as Ms. Spalding was talking about, and mentioned that adult is not defined in our sections here. I guess I never thought it needed to be defined if we define minor, but do we feel like we need to put that not just here, but generally in all of our documentation, or is that something that has been just overlooked, and or do we need to add it, or kind of give me some thoughts about that?
Well, the team and I had discussed that as well prior to the meeting, and it does set out that in our rules that the employee has to determine whether or not, has to check the ID and determine whether or not the individual is an adult. And then, like you said, we don't have adult defined, but it does say that minor is anyone under the age of 21. And so I don't know if it would be better if we rephrased it. I mean, it sounds kind of awkward if you say to make sure that the person's not a minor versus if you just said to make sure that the person's an adult. So I would be happy to add something in our definition section that pertains to an adult, anyone that has attained the age of at least 21 years of age.
I think it's clear here, and I'm only asking just to make sure from, I'm always about the language and communication and making sure we're just super clear. It seems very clear to me, but I just always want to make sure.
Right.
If it's not clear to someone, if it came up, then somebody is unclear.
Right.
So I think it's clear in this regulation or this set of rules, but, you all have done a good job of keeping a fluid document, so I would just suggest maybe we put something in.
Okay.
So my comment to that, and this is a legal counsel question, is do we not define something to this effect in our rules in other places?
I don't know off the top of my head, but if you have minor defined, I think it's pretty clear from that what adult would be. I don't think that it would hurt just to have a definition of adult, just for clarity's sake. But in terms of whether the term adult is defined actually in the beer board rules, I don't believe that it is. I'm not aware of any place where that is actually defined.
It is not.
And then the other suggestion was under K, just to round it all out. And that would be no different than any other, adding that language would be no different than any other rule we have. I think about like the safety and security situation with brick and mortar, how we hold them accountable. We would hold them accountable also to reprimanding someone on their vehicle who was being, disorderly in some way, so.
So to the director and legal, let me take these just one at a time. And okay, first, when did we get this?
They sent that this afternoon.
Okay. So to MNPD, thanks for sitting at the last minute. I say this in jest with a smirk on my face if you're not here. Obviously, we can amend this and then accept and then or adopt the amended version. And to the board and to those in the public and on the call, the idea is these do not go into effect until we adopt the minutes from today's meeting at our next meeting, which is scheduled for next week. So just understand that that's the reason we're meeting today, so that we can get to an adoptable document and to create an adoptable set of rules and regulations.
It's actually on Thursday. This Thursday.
Okay, in 2 days then. Okay, today is only Tuesday?
Yeah.
Okay, got that right. Anyway, at our next meeting, whenever that meeting is, and I'm being told it's Thursday, so. So are these changes that we think we need to make, we should make? Are we leaving any holes or gaps if we don't? Is there any reason not to? Or is it better that we do? I'm looking at legal counsel.
Well, that's something that I would just leave up to the board's discretion. I mean, legally, it's fine if you do. I think I don't see any issues with making those changes or not making those changes. So, yes, I mean, I think that would just be up to the board to decide how it wants to amend the rules.
Yeah, the only one for me that's just not addressed is K, because we don't address really I don't know that we address in any of these the patron side of it. So we talk about their license or not operating a disorderly mobile establishment, but as you said when we got started, there's lots of room for interpretation of what that means. Am I driving incorrectly, or am I allowing certain behavior that we've all seen on these vehicles? And so I do believe that that's the one that I would want to push for. The other ones to me are, adding the adult piece is not really a rule. That's more of just a best practice for us as an office. I think we already addressed the provision about complying with all state laws and ordinances
Right.
in N. So K is the only one to me, just to make sure it's very clear. But I can be convinced that it's addressed someplace else, but it's the only one that I see that's more glaring.
We do have one section that pertains to, and that's under section C, under C, where it says it shall be a violation for any customer or employee to throw an object from the premises of a mobile beer permit establishment.
Yeah.
And so that is one area where we do address the patrons on there, but
I just get concerned about that doesn't
Right.
address a fight, or
Right.
that doesn't address, other types of behaviors that can happen. I mean, certainly throwing is terrible, but there are many other
Right.
things that, again, I have personally seen. So,
so I don't have an issue with adding that.
and maybe it gets added, to C more than to K. I don't have a particular place, but I do believe making sure it's very clear that you can't just drive and go and let people do whatever
Right.
behind you. Not just a beer piece, but also a safety piece.
Right.
Not just what they're drinking, but also what they're doing.
So I understand your concern, and I understand why, but so that we're not trying to get down into the weeds, it is always the permit holder's responsibility that their place of business is operated in an orderly fashion. Doesn't matter what is being done inside or who's doing it. If it's a customer, they have the right to evict that customer or move them off the premise. They are still responsible for all the actions that happen at their establishment under that permit.
Yes.
So to me, again, I understand the concern. I personally don't think this change is needed because the permit holder is always the liable one. They're always the one held responsible. Now, if the customer or patron is doing something that the police need to be called in for or what have you, then that's a legal matter with the Metro Police Department. It's still the only persons we are going to see that we can hold liable as a Metro body is the permit holder. We can't cite that person who pulled a gun or pulled a knife or started a fight. We have no control over those because we don't have authority over that person. We only have authority over that beer permit holder. So that's my argument to try to convince you that I don't think this is needed because of the authority that we are already granted under Metro law.
How do we address it in the situation? I'm thinking about, we've had several situations where people come in with a brick and mortar and behind their building is something happening and we cite them for that. Is that not listed in the rules?
If it's on, and I'll let legal and the director chime in too. If it's on their premise, they're responsible, period.
Right, and so that's listed someplace.
If it spills out of their premise into public space, they are still responsible because
Yes.
the issue began in their permitted premise.
Correct.
And that-
So where is that listed? That's my only question. Where is that listed?
We actually, that's actually a Metro code where it discusses in one section about disorderly conduct, but also criminal conduct, criminal activity. That's where we cite them a lot of times.
Okay.
If there's a fight or drug sales are taking place, then we can cite them under that. But you're correct. There is a specific citation for that.
Yes, and we have a lot of attorneys in this room and a lot on the line. And I know what will happen. We'll sit here and we'll hear this. And I just always want to make sure that I say that before we move forward. I'm fine with it, but in other places we do cite that. And I just also want to make sure that people are educated about what they're getting into when
Right.
they decide to do this. So that's the only reason why I'm stuck on that one. If it's listed other places and it's very clear, I'm fine with that because this is covered. Because it says it in a few places. I even see it under I.
And I will add to that as well that we are likely to have many more rulemaking hearings in the near future, and so this is something that really this really sets forth a framework, an initial framework, and so we're all new to this particular aspect of it with the mobile beer permits, and so there will be times, I'm sure, when we need to make tweaks to it. So this will not be the only time that we have to make any changes that you all see as proper in this case.
Sure, and let me add to that. And Director, thank you for saying that. And because if I didn't earlier, I meant to allude to that this is a draft. As I did say, there will probably be continued changes to this rule. My preference of this today, and again, I'm just one of 5 here today, and I don't vote unless I need to break a tie. That unless there are some material changes that change the impact or effect of the way these rules are applied, my preference, again, I'm just one of 5, is we adopt them with the idea that if we think some of these changes, and we can even have a further discussion on Thursday after we had potentially adopt these today, approve the minutes, therefore they are adopted. Additional changes, we can have a discussion about some additional changes to maybe change the way it reads, maybe to satisfy some of the concern of MNPD about the definition of adult, maybe give some more thought to Ms. Jarman's concern about the disorderly conduct definition or the way it's stated, because we certainly want to be as clear as we can and not leave broad gaps for interpretation, which that's what attorneys are for, as you alluded to. But again, I say my preference is that we adopt them as written unless we see that there are some material changes so that we don't get caught in the weeds. And then if you have any commentary, then you can connect directly with the director, because we can't do this as a we can't do it as a body outside of a meeting. To maybe clarify some of these things, like Ms. Jarman's definitions of MTLC, MNPD, TABC. We all know what they are, but having them spelled out makes perfect sense. So I'll be quiet for a minute to open up any more concerns, discussions. Turn your microphone on, please.
I would just say I'm on board for that, and I also share, I think, probably Ms. Jarman's concerns just about that, that education piece where people might think, well, maybe it started here, but then I kicked them off and it's not my problem anymore, or something like that. I think, just that, making sure not only is it written, but somehow really brought to people's attention that the conduct is relevant to their having this permit. But I totally agree with passing these and then keeping a
Sure.
thoughtful eye to those parts.
It's valid concerns, and I know there's probably not a member of this board who hasn't said to someone sitting in the audience or sitting in front of us that it's not our responsibility to ensure that you understand the rules. It's yours as a permit holder or as someone seeking the permit. You sign on an application that says you understand. At some point where you don't, if you're requesting a permit, then it's on you. The liability is on you to ensure that you do, to call the office, to talk with staff who is more than welcome to spend time with you, as they do regularly for new applicants, to do those pre-inspections or have those Q&A sessions that are really one-on-one. That's not going to change. And we're not going to, we're not going to define or create a rule or regulation for every potential situation. So there does need to be some degree of vagueness in some of the in some of the language in these statements. But because, again, we aren't a court of law. Our adjudication of actions or perceived actions or alleged actions, let me say, is based on preponderance of the evidence. It's not a criminal matter. So with that, I'll stop there. It's just kind of further clarification on the mindset that we need to take. And again, I will state again that for those in the audience and on the call, once we're through with this piece of the meeting, we'll go into some Q&A to allow people to ask some questions. Any other comments from the board? Any comments from the director?
Not at this time. Thank you. And I appreciate the discussion as well and the questions.
Okay, so the motion on the floor is to adopt these rules and regulations as presented. There was a second. We've had discussion. At this point, I will call for a vote on the motion to adopt these rules. I'm sorry. I'll entertain a vote. All in favor? Let the record show there were 4 ayes. Any opposed? No opposition. So motion passes. The new mobile beer permit regulations, creating a section 6.01, a 6.02, and a 6.03 in Metro Beer Board rules, or let's say beer laws of Metro government, has been adopted. Again, to the board, if there are any other issues or questions or clarification requests, we can always, going forward, we can address those. We have historically changed a rule as we see fit or as needed. So now, we do have a few people in the audience, and we have a number of folks online. Sade, for those online, how do they let you know that they have a question?
For the users that are on the Webex, they will need to raise their virtual hand. Once we've called upon them, they will be unmuted and they can ask their question.
Right. And will you be the proctor? Okay. So we do have a few folks in the audience. Let me see if we can go back and forth. So is there anyone in the audience who wants to come forward, ask a question? Yes, ma'am. I'll ask you, make sure you turn on the microphone so we can just pick this up.
And also
And-
be sure to state your name for the record.
Please.
Yes, Rachel Lawson with Dickinson Wright. Just a couple questions. I see we've got the mobile beer permit and the mobile BYO beer permit. I take that to understand those are two separate, distinct permits.
Correct.
Can you have both?
The director and I have talked about this, and our intent is that you can.
You can. Okay.
So that you can allow someone to bring their own. Or you can sell it. Because at the end of the day, the permit holder is still responsible for the actions of those on the vehicle.
Gotcha. The only other question I had, we see we have a copy of lease. That's, I mean, most of these transportation companies have a base of operations.
Correct.
Are you guys going to be having, looking at distance issues with those? Does the 100-foot rule going to apply to those locations?
I think from an on-premise scenario, and Director, we have discussed this, but from an on-premise scenario, in other words, at the home base, my take is that they still have to operate under that 100-foot distance matter.
So is there a mechanism? I know we've had this issue before where there was an issue with the distance, the ability to overcome a distance issue didn't exist for manufacturers until we changed it. You know, we tweaked some things a few years ago. Is that exemption procedure going to exist if we've got a distance issue with one of these?
Metro law has the ability to get a distance waiver for an on-premise, not for an off-premise.
Okay. But what is this?
An off-premise meaning like a C-store, convenience store, something where a customer comes in, buys it, and takes it off-premise.
Correct.
In this case, a mobile permit is not really an on or an off, it's a hybrid.
Sure.
There's a reason. It's a mobile beer permit, not an on-premise beer permit or an off-premise beer permit. Our take is that the on-premise location, in other words, if home base, at a home base, they do need to follow the 100-foot distance guidelines because they still can't fall within 100 feet of a school, park, church, playground.
Right, because, I mean, all of these permits, you need to provide a lease. So, but what I'm asking is, you know, like manufacturers until recently didn't have the ability to go and go to the council and get
A distance waiver.
correct. Are we going to have that mechanism if that is an issue with some of these?
Yes, ma'am.
permits? Okay.
Yes,
that's-
we see, again, it's an on-premise. For any on-premise, you have the ability to get a distance waiver.
Okay,
They fall under the on-premise
they will,
definition.
okay, all right. I think that's all I had. Sorry to be so, like, right out the gate, deuces.
That's pretty simple coming from you, Ms. Lawson. So, Sade, do you have any online questions?
Yes, Emmett Martin, you are unmuted.
Mr. Martin, welcome.
Hey, welcome, everybody. Or, hi, everybody. On the mobile BYOB beer permit, I'm reading from your rules. Means a permit issued by a Metropolitan Beer Board that grants mobile establishments the right to allow a customer to store, open, and consume BYOB on the mobile establishment. My concern for clarification is from the beginning, we have controlled the amount of alcohol being consumed by our customers via our staff, our bartenders. And I just want to make sure that we can continue to control the amount of alcohol that consumers drink by us serving it to them and not letting them just free for all it. And I don't see that cleared in here.
So, Mr. Martin, let me restate the question so that I understand, because it was kind of difficult to hear the last part. You just want to know that as an operator, you have the authority to control the amount of consumption. Is that what you said?
Yes, specifically with our staff is the ones who get the alcohol, put it in our coolers, open it up, and serve it to the customer instead of letting them just get into the cooler and get it themselves whenever they want.
So our take is that the mobile BYO permit allows the permit holder to allow someone to bring their own beverage, their own beer.
Yes.
Clarification, beer. The customers, they can open it themselves, or the operator of the vehicle or whoever is designated from the business standpoint, you have the ability to open it and hand it to them. At the end of the day, you're still responsible as the permit holder for ensuring that they aren't overserved. Just like in a brick and mortar establishment, if someone is overserved, they leave your establishment and they cause damage or harm to the general public, you are then held liable. In this case, that is no different.
Absolutely. I totally agree with that. I just wanted to make sure that it was clear in the rules, because it only says the right to allow a customer to store open. And is it possible to clarify and include the staff?
To that point, I would say that, okay, any clarification is possible. Any additional clarification is possible. Mr. Martin, what I would ask is if you would, and I understand your point, I go back to the point that we're not going to create language for every possible situation, but we want to be as broad and as specific as we can be without getting too deep into the weeds. If you have some commentary with the way one of these definitions are written, or that you have some concern or maybe even some clarity, if you would send that to the director or the staff, your comments, and then we can take them under advisement with regard to the way the rules are codified or the way the definitions are, the way the definitions exist. Does that sound okay?
Yeah, and I just wanted to point out that is a one. Since we're being specific in these rules, that is a specific thing that somebody could take it upon themselves to maybe stop us and say, well, I'm looking at these rules and it doesn't say that you're allowed to touch their alcohol. And I just wanted to be clear, we are really responsible operators, and we've been serving, we've never allowed guests to serve their own alcohol. And I want to make sure that that's just very clear, because we don't want that. I don't think you guys want that. I don't think anybody wants consumers to be able to just go and get their alcohol without us controlling it. And I just want to make sure that if it was specific to, say, the customer, that this is a big enough point that it should include specifically the staff. And yes, I will send that over to you guys.
That would be great. I'll default to, this body is not here to tell you how to run your business and what you tell your customers you can and can't do. We just trust that, that all, we go on the faith that all operators are operating in a safe and effective, well-mannered.
Yes. We want to make sure that we're following the rules, though. And I just want to be clear that if it doesn't specify that we are allowed to do it, I don't want somebody coming out there from the police or inspectors or the city or MTLC to say, I'm reading this and you're not allowed to serve beer. And that's the only concern that we have, is we're trying to follow the rules, and we want to make sure that the rules are clear for the people that are going to enforce the rules upon us.
Sure, that's a fair concern. And as I said, if you want to send that commentary into the beer board office,
Okay.
if you do that sooner than later, it's probably something we could look at on Thursday.
Okay. Appreciate that.
You bet. Thanks.
Yes, sir.
Any other questions? Mr. Martin?
No.
All right. Hey, thank you.
Yep.
Okay. We have an audience member with a question. And if you would, state your name for the record. If you would turn the microphone on, if you would, please. Nope. There you go.
All right. My name's Grant Rosenblatt. I own the Honky Tonk Party Express, and it's an open-air party bus company that operates in downtown Nashville. Thank you all for letting us come and have this meeting and talk. I have a few questions, but, you know, I don't know how much time that we have on this, but obviously this is very new for everyone, especially us. Just clarification, what is the percentage that we can serve? Like, what is that limit and below? Do we have that?
You're talking about the alcohol
Yes.
content?
Yes, sir.
8% and below
Making sure.
by weight.
Okay.
As defined by TCA.
Will the permits be associated with a company, or like one company has one permit for all their vehicle assets, or is it going to be issued per vehicle asset?
Per vehicle.
Per vehicle asset.
So that if you have 5 vehicles, you potentially could, Mr. Rosenblatt, have 2 permits per vehicle.
Okay.
Like
Two
you
permits.
could have a BYO permit,
Correct.
and you could have an on-premise or a
Understood.
a mobile beer permit. Yes,
Yes.
thank you.
And on-premise. With the on-premise, and I know we're talking about mobile, but if there is a location where we load and unload, and they're able to buy on-premise and then take that into the vehicle, not purchase it on the vehicle, but take it from a brick and mortar, walk outside, load onto the bus. What rule is on that? Can it be an open container? Does it have to be a closed container, or is it kind of all together?
So give me an example. I think I know the answer. I think I know what you're
So I
asking,
go
but
into
just
the
for
location
clarity.
where we're loading up with our vehicles. They come in, they can buy Jackalope beer, whatever they want, and they would come out and load that onto the bus. So is that, if they buy it from, not bring it, but they purchase it from us, are they able to open it up, drink it, load onto the bus at our load-up location, or does it have to be a closed container leaving from essentially a retail store into the bus?
Are you talking, is the loading area on premises?
Yeah, so we would have for us, this would be our private location, private property.
And it's property you personally own?
Or
is it someone else?
lease. Yes, sir.
That you lease, okay. I mean, I think what we intended in a situation like that is that I believe you could open it and get on the bus at that point. But if we're talking about, for instance, I think in the past, if you were down, say, on 2nd Avenue,
Correct.
went into a location, and you went into an on and off sale location and brought the beer outside, it would have to be in a sealed container to leave the premises of the off sale location, and then they could open it once they got on to the vehicle at that point.
And that has to do as well with the fact that you're going onto a public
Correct.
domain.
Correct.
You're crossing a sidewalk.
That is correct. Do we have a cost that are associated per permit?
$250 per permit.
And in terms of permits, is there a limited number, or is it as they come and apply? Okay.
No limit, sorry.
I mean, I think you can only have 2 per vehicle because that's all you would need.
Correct.
But if MTLC licenses or gives you X number of license, then you would need the according or the associated permits to then serve beer or allow beer to be consumed on the vehicle.
Okay. Also, too, is the mobile beer permit for unenclosed vehicles or like charter buses, shuttles? I'm talking about wedding shuttles or a charter bus that's coming from Memphis that, they do tours from Memphis into Nashville or from Kentucky that come down here. So like who would be applying to have, to be able to sell in there or to have those open containers, I guess?
So my response to that is that's the clarity that you're looking for there is really in the new law that was just passed in Metro Council. And to the director, I'll allow you to go into that a little bit further, but our rules address those that are allowed under the new Metro Code that was just passed 2 weeks ago.
Okay.
That Councilman O'Connell.
So I'm assuming when the TLC permits those people, those are the people who are going to be applying for the mobile beer permit.
You're currently talking about entities that are not permitted by TLC, is that correct?
Correct. I mean, you've got companies that are operating in Williamson County that are coming up here. I mean, wedding industry is very big here. Sightseeing and tourism are very big
Right.
here as well too. So
Yeah, the way that it's set out right now is that one of the requirements that we have is that the entity has to be previously licensed by MTLC before they can obtain a beer permit. So that's one of our minimum requirements.
And that is under the rule, section 6.01, mobile establishment. And again, mobile beer permit is congruent with mobile establishment. Mobile establishment means a business permitted as a pedal carriage, horse-drawn carriage, or entertainment transportation vehicle by the Metropolitan Transportation Licensing Commission pursuant to Title VI of the Metropolitan Code, or an affiliate of such business with common offices or LSO managers. So to further what the director just said is that our rules are only concerned with those entities that are licensed by TLC.
understood. And I have just two more questions.
Sure.
And I don't know if I have time.
We're not rushing you.
If we have a vehicle that is stationary, the engine is off or it's non-moving. So, example, we do tailgates with the Tennessee Titans and Music City Bowl and stuff like that comes along. Are those vehicles going to be required to do what they normally do, which is it's in a private parking lot? Would we need a permit for those type of vehicles as well too, for them to BYOB when it's non-moving, when it's stationary? Really making y'all think on these today, guys. This is like...
So paint a picture of what you mean by the tailgate. Did they get there on your vehicle?
No. So what
They
we'll do
didn't
is-
load on your establishment? They didn't ride your vehicle?
They do not ride our
They were
vehicle.
not companion on your vehicle? They're just coming to tailgate for a game?
Correct.
In a parking lot?
The vehicles are rented out as just a pre-booked spot for people to load on to. So mainly for out-of-town teams that are coming in, they don't want to bring tents or they don't know where to park it. So they just come to us and say, hey, we've got 15, 20 people, and we park our bus. They show up in an Uber, whatever. They just load on the bus and they have music going. They have their own drinks. They bring, their food.
You all don't provide any beer in that
It's all,
situation?
it's all from them, BYOB.
Well, at this point, you're saying bus,
Yes.
and
Right.
I don't know that this matter. Again, our concern is if it has to be TLC licensed.
But I would also add that I don't think that falls under our special events in that case, since you're not providing the beer either in that situation. So I think what do you guys think, Terrence?
I was thinking the same thing. It wouldn't be under the special event. If you're not providing it, you're not charging a fee or anything like that, right?
The only thing that we're charging for is time for them to be on the vehicle.
But it's not going anywhere.
No.
It's just sitting there. It's basically a box.
And they're bringing their own beer?
Yeah.
Okay.
I mean, you're going to get that with other, like at Titans games or I mean, you'll see those vehicles out there. This is more of a kind of in the weeds question, but worth asking that we had questions on.
Sure.
As well, too.
I mean, it's a valid question.
And it sounds like the reason why you're asking the question is because this vehicle would be permitted under the transportation. Like, this is gonna be the same vehicle you use out.
Correct.
To do. So this is why he's asking the question, so that when our inspectors or police roll up and say, what's happening, that they're not confused about you're sitting, this is the same vehicle you use to be out on the streets too.
Right.
Right, okay.
Now, I think if, in the future, if that does fall under MTLC in that case and you're renting it out, then I think the factor right now is the fact that they're not permitted by MTLC currently. And so if they were, then I think you would have to get a beer permit in that case due to the BYOB.
Okay.
But I think as it is right now, it doesn't apply in this particular case, and it doesn't fall under our special events.
Okay.
So we don't have authority until we're granted authority.
Yeah.
And we're only granted authority once TLC licenses it.
Correct.
And if TLC hasn't licensed it, if you're selling it, you're violating the law because you're selling a controlled substance
Correct.
without a permit. But again, once TLC has authority to license it, a bus, we have the authority to issue a permit. And then if you have people on that vehicle and it moves with those people on there, then that's where our authority comes in.
Okay. It's moving. Gotcha. Understood.
Good question, so.
But I just want to put a pin there for just a half a second. The moving piece, that piece probably is a little bit sticky. So, and I only say that because we're going to get this question again. A vehicle doesn't have to move. And so I just want to throw that out there just from let's bring it back up again, because I think that's going to be a question that we have, from time to time.
Okay.
I think it's a good point.
And then I've got so many, but and this has just come from our safety point. Any alcohol or any a liquid container we put into a plastic cup. That way, there's no cans or bottles that fall over the side of our vehicles. Is that under y'all's authority to put that in there, or is that up to the operator to make that decision?
Does the ordinance not require, does the ordinance address the bottle can matter? I thought that was addressed.
Do you remember if it?
As we were assisting in the
I don't think
drafting
it
of
does.
that,
It was
so.
just more of like, in the mobile realm things, it's, I mean, if you have a bottle hanging over versus like a plastic cup, there's,
It's
I just didn't know if that was
in
an
the-
operator or if that was going to be something that would be put in there as well too.
Yeah, I unfortunately, we don't, but I wish we had a copy of the legislation.
Pull it up.
I want to say, until we have confirmation in a moment, that the ordinance says you cannot have glass.
Okay. Yeah, and we follow that rule.
I'm happy to be
I mean,
corrected,
Yeah.
but I'd be, if it doesn't,
Okay.
stay tuned.
And last question, and I appreciate y'all's time. The issue time of getting the application filled out and turned in to the actual beer permit being issued, what is that time frame? If everything is no snow, no COVID shutdowns, anything like that?
Mr. Rosenblatt, that's a good question because, again, the department has been working with IT
Yep.
to get it online. In theory, the process shouldn't be any different than your typical on-premise brick and mortar type permit. But I think it's going to be a fluid process as we begin. So if I gave you a time frame, I would be giving you information that's
Correct.
above my pay grade.
Okay.
Well, and I'll just add that we don't give timelines even for the brick and mortars.
Yep.
It just, once you have everything submitted, then we can give you a temporary permit at that point to operate on until it's such time as the board can
Okay, that's good. That's good to know.
hear that. So
That's all the questions I had. Thank you all again
Sure.
for y'all's time.
Thanks for being here.
I do, he brought up something that I think we addressed, but I would like to see us address it again, maybe not today, but about that open container piece, moving from the private location onto the vehicle. I feel like that's going to get a little sticky because people are going to say, oh, we walked down the street from someplace to get on the bus. And so I just feel like at some point we need to address that piece about the open container, if that's going to happen, go from a location, a private location to the public vehicle. That I just think it needs to be addressed. And then two, I think we've gotten some good questions, and I know that the staff will do this, but I'm putting it out there that at some point this will be updated on the FAQs, because we're getting a lot of good questions that I think are not necessarily, they don't need to be in the rules because the rules are clear, but they need to maybe be some of those more common, frequently asked questions. So those are just my 2 points.
Now, I will add to that I believe it's in the ordinance that as to whether or not you can cross either a public sidewalk or a public right of way. And my take from what he was asking is if you're in the parking lot, for instance, of the business that you lease, and you're out in the parking lot, can you open it at that point in the parking lot? I think it's a totally different story if you're talking about opening the container and then walking down the street with it in its original container. I think that poses an issue.
Yeah,
then
you can't do that.
Yeah, may I ask you a question? You have a private location. Are they in the parking lot going to your vehicle, or are they going from your location across the sidewalk to the street?
Everything that we do is in a private lot.
Okay. Okay.
So the way
I just wanted to clarify, because it didn't feel clear to me. It felt very much like Memphis.
Yeah, I mean, the way the ordinance is written and then combined with our rules, you can't anywhere in Metro take a beer that you bought on a premise and walk off that premise and walk down a street.
Absolutely.
You cannot do that.
I got it. I want to make sure it's clear that that's not what we're giving permission. That was it, yeah.
Valid point. Sade, next question from someone online.
I think this is more of a statement that Dustin Olson was going to make. Dustin Olson, I am now unmuting you.
Mr. Olson, welcome. Dustin Olson, are you there? Going once. Mr. Olson, are you there? You are unmuted. Going twice. If we could mute him and maybe he'll come back to us. Sade, thank you. Anyone else in the audience live?
He stated that his mic doesn't work on his computer, but he did want to state that it's already listed in the MTLC regs. That was his statement.
All right. Anyone live have a question? Yes, ma'am. Again, remember, if you would, state your name.
Yes, sir. Hello. My name is Jan Margaret Craig, here for Nashville Pedal Tavern, which has 10 carriages and has been in business since 2010. I wanted to follow up on some questions that were brought up by the previous in-person speaker about the beer permits for the vehicles and as that relates to the licensed premises for these beer permits. Our understanding of the legislative intent behind this new ordinance is that the licensed premises of the mobile establishment would include the business permitted as I'm going to mobile beer permit where it says beer may be sold, served, and consumed in the main office, patio, or on carriages or vehicles. And our understanding of the intent behind that was that the premises would include all of those spaces, the office, the patio, if the business had that, and the vehicles, so that the beer could be opened at the office and taken to the vehicle as discussed, if that was all part of that licensed premise.
Right.
I believe it came up about having multiple permits for per vehicle as opposed to per the business at large. And my understanding based on the intent was that the business would receive the permit, thus allowing people to take the beer throughout the licensed premise. If the vehicle has a separate permit from the business, potentially, then just want to make sure that doesn't create issues with what's licensed. So I guess my question or my comment is that as we understand this, this would allow the business itself to be permitted.
So the answer to that piece is yes. So
Okay.
I think your concern, and I'll state this, and please correct me if you intend to query differently, is if you have permits for your vehicles and you also have a permit for the establishment, you've got potentially overlapping permits on the same premise sitting there. So our intent is that the home office, home base, whatever you want to call it, has a mobile beer permit. License is on the wall there. All of your vehicles at some point in the day, to start off the day, are all parked in the lot. You have people come on to load for that first ride of the day so they can buy beer in your home store, your home-based store, and then take it to the mobile vehicle, which is also licensed. And the only way they can do that is because they have that mobile permit. In that case, that's a mobile BYO permit because they're not buying it on the vehicle. The mobile part of it, and the reason why the vehicles need to be licensed, is because they're going to roll off the premise. So, as kind of a historical matter, we have been discussing this concept now for 3 years, at least, because we realize this is opening the door for, again, hospitality folks to find openings to say, well, you didn't tell me I couldn't do this. And again, we're not going to legislate every possible situation, so we're kind of going with, we're going with it here. It took us a long time, and it took us till now to get our head around the definition of premise, because in Metro Code and in our rules, you couldn't have a beer permit without having a premise. You had to have somewhere to sell it. Part of your application process is defining where you're selling it and where you're storing it. This is no different. We're just creating the ability for that premise to move. So you had asked a question before the meeting started about, I won't call it a misunderstanding, but clarification. Why couldn't you just have one permit for the business and it cover all of your vehicles? Well, if you have, as Mr. Rosenblatt, if he's got 10 vehicles out there, now he's got 10 mobile premises out there at some location, and that location is changing every moment they're moving. Hence, the reason we're here is to create a mobile beer permit so that we can better maintain order. And order is however someone may want to interpret it, or however it is presented to us in some situation down the road. But the idea is we're granting latitude for the mobile establishments, those that are licensed by TLC, which gives us the authority, to go back to doing what you're doing, but now you're doing it in a much more regulated manner. So the idea that there are some of those in the public that had a large concern over, and I'll use a term I've heard many times, is the Wild Wild West downtown. And hence the reason it got removed entirely back a few months ago by Councilman O'Connell's initial legislation. So we're bringing it back, but we're bringing it back under a much more regulated concept. And now not only does the Beer Board have authority, so does Metro Transportation Licensing Commission. So the general public, I hope the way it's accepted is we went from an environment where you weren't regulated at all to now you're regulated by two different metro authorities that have the ability to work in conjunction with one another and to report to one another the things that they're seeing and the way that operators are functioning. And I don't know if I answered your question in a very long, circuitous manner, and I'm hoping I answered the question. So Ms. Craig.
I believe you answered my question that within this framework, it is intended that the premises can include the office, the patio, if there is one, and the vehicles.
So long as those vehicles are sitting on that premise. Once they roll off, they have to have a mobile permit for themselves individually.
And they can have up to 2 permits.
Yes. Okay.
So that permit you have at your home base, at your office, in your patio, that's the permit for just the home base, the premise that doesn't move. And you can sell beer like you have an on-premise license, and you can sell your patrons beer to carry to the mobile vehicle to then roll off the premise, off the fixed premise.
Yes. And I believe I do understand. My question was more about, my comment, I should say, was more about the intent that the business be permitted versus multiple permits.
The intent is both.
For
If you're gonna have beer at the premise, at the fixed premise,
yes,
you have to have a permit for that location.
and I understand that, but since the business premise includes everything.
So what she's talking about is having 1 permit for the business that you can move about.
Yes.
What we're saying is you're going to have 1 for the physical location, the main home, and then you say you have 10 vehicles. So you're either going to have 10 or 20 permits that go on those vehicles, 1 or 2 on each of those vehicles. So when they leave that location, you're going to have either 11 or 21 permits. That's what we're talking about, just from a number standpoint. And I think that that's drastically different than what you were maybe thinking about. So that's why I wanted to just be clear.
I understand, yes. And so that is where, I apologize, I was trying to find the ordinance. Based on the ordinance, I was reading this as permitting the establishment itself. And the definition of the establishment including the business.
You would need for the business, you would need a mobile beer permit, and then if they're going to take it on board, then you'd have to get a BYO for each vehicle when it allows the beer to come onto the vehicle. And then if you're going to sell while you're on the vehicle, then you would also need a mobile beer permit
For those vehicles.
for those vehicles as well.
I understand what you're saying.
But I think what, like they were saying though, if people are going to come and just sit on the vehicle and it's just going to stay on property and not move at all, I mean, that's totally different where you're talking about that's just going to stay on there. But, we're talking about vehicles driving all over the city so if you're talking about that, then you would need the separate.
But they
one
would
for
be
those.
able to then take the beer from the office to the vehicle.
Because of the BYO.
I understand. Thank you.
Sure.
Thank you.
There are no other questions or comments from the virtual space at this time.
I'm sorry, say that again.
There are no other questions or comments from the virtual space at this time.
Okay, thanks. Anyone else in the audience have any other comments, questions? So to those that are here, thank you. You've had some good questions. I will refer back to my earlier comment. This is a fluid process, and again, we fully expect there to be tweaks as we move forward. And as folks in the hospitality in this particular mobile domain to test the system to help us find what we've missed. And we appreciate that, as always. Again, we've been working on this concept long before Councilman O'Connell and the powers that be began pushing back on the whole mobile concept. We've been discussing it for at least 3 years on how something like this could be done. Because, I mean, sometime, we've got food trucks that are named specifically in the ordinance. So it's on us to continue to work to put some guidelines and some guardrails around that concept. We're always open to public commentary, public questions. Again, we've had some great questions today. There's some answers I felt like we were firm on. There's some answers I felt like that we probably need to get a better grasp on, because as we created this document or these rules, the way we interpreted what we were saying, obviously, potentially is much different, hopefully not, than those in the general public that are going to be applying for these permits. So, again, bear with us. Feel free to ask questions at any point in time. Again, to the board, thank you guys for your time, for your questions. There's some good stuff coming out of this. Much like the delivery and curbside, the Metro Beer Permit Board here in Nashville, Davidson County is creating something that doesn't exist anywhere else in the state of Tennessee. We could be called that, Mr. Perlin. There's probably some other choice words for others out there that doesn't follow the positive manner. But again, thanks to the staff. You guys have put a lot of time and effort into this. Director, thank you for leading this charge.
Thank you, Mr. Chair.
Absolutely. Any other comments, Mr. Director?
I just wanted to thank the board and my team as well, and legal counsel for really working hard over the last 2 weeks. I mean, longer than that, but really trying to put this forward and really make something out of where nothing has ever existed like this before. So I hope everyone will bear with us as we kind of figure out the directions that we're going and what all we need to do to make this successful. So I appreciate that, and appreciate the mayor's office and the administration for their support, and also many council members, including Councilman O'Connell, for his support of this as well. So thank you very much.
Very well. Any other comments, questions? Hearing none, folks, we stand adjourned. Thanks so much.
See you Thursday.